Secretary Bellows, just to start, because I think over the last few weeks, people have been seeing similar type ballot decisions being made across the country. But of course, every state kind of has its different statutes and laws and who can do what. So if you don't mind just kind of explaining why you, as Maine Secretary of State, were tasked with, these public hearings and then eventually making this decision.
It's important for Maine voters and the citizenry to understand how the process works here in our state. Because every state controls elections. That's why we have different voting rights laws, different election laws. And Maine is unique. To my knowledge, we're the only state in the country where once a candidate is qualified for the ballot, which I did qualify Mr. Trump initially, any registered Maine voter can bring a challenge under Maine election law to the candidate's qualifications. I am then obligated by the law to hold what's called an administrative hearing. It places me in the role as an adjudicator, the administrative hearing officer, not an advocate. I must hear testimony from witnesses, hear evidence from both sides. They may be represented by attorneys. And in fact, Mr. Trump was represented by counsel, and so were the challengers. There were 5 challengers and 3 challenges. So Marianne Royal, Paul Gordon, and then 3 former state senators, 2 former Republican state senators, Kimberly Rosen and Thomas Saviello, and former Democratic state senator Ethan Strimling. So under the law, I held that hearing within 5 days of the challenge, which is my deadline to hold a hearing. And then similarly under the law, I must in fact issue a decision a week after the hearing process concludes. So after those final briefs were submitted, I then had 5 business days to issue my decision, which I did yesterday in compliance with my obligations. Now it goes to Superior Court. And at the end of my decision, I did suspend the effect of my decision until the Superior Court can rule or the appeals process expires. So this will go to the courts. The courts will make a determination. I, in my role as secretary, will follow the Constitution and the law.
You legally had to make a ruling here, is that correct?
That is correct. I was legally required to hold a hearing and required to issue a decision. I did not have a choice to decline to decide. Then it goes to the courts, and the courts can either uphold my decision or overturn it, and I will follow the law. Whatever the courts determine is what we will do.
Great, thank you. And Secretary Bellows, yesterday, in anticipation of this decision, I spoke to folks who were in that public hearing, both supporting the challenge and those supporting former President Donald Trump. And those in favor of keeping Mr. Trump on the ballot said that if he was removed, it would disenfranchise voters. And I know you have come out saying that voting and democracy is sacred in our country and in our state. So would you agree or disagree that removing him from the ballot is disenfranchising the voters if they want to make their vote for president for Trump?
Under the law, I'm required to make a determination of qualifications for office as set forth in the Constitution and Maine. So last week, for example, the Superior Court upheld my decision to bar Mr. Chris Christie from Maine's presidential primary ballot because he failed to gather adequate signatures. This is not unusual. I and my secretary predecessors have done this before me, and making an evaluation as to whether the candidates who have requested ballot access do in fact meet the qualifications to hold office. That is a requirement that I have to abide by. And I am mindful that no Secretary of State has ever deprived a presidential candidate of access to the ballot under Section 3 of the 14th Amendment. But I'm also mindful that no presidential candidate has ever before engaged in insurrection, and that is a violation of Section 3 of the 14th Amendment.
And to that point, I don't know how in-depth of your decision making and the process you want to get into, but as you said, very unprecedented. You're the first Secretary of State to make this decision. So how did you kind of again, there's really no precedent to look at here. So how did you kind of consult, if you did, with other folks to end up where you did?
My sole obligation under the law was the oath I took to uphold the Constitution and the requirements that I only consider the evidence presented at the hearing by the parties, the exhibits, the testimony, and they make a determination based on those facts and the law and the Constitution. That was all I was allowed to do. My political affiliation, my personal views of January 6, 2021 did not enter into my decision.
And just some more kind of bookkeeping questions, I guess, for lack of a better term, because I know the ballots do need to be printed and finalized. So what does the process look like, again, as we wait for a decision from the court? So when do the ballots need to be finalized in our state so they can be shipped off to, military members and absentee voters?
So voting for military and overseas voters starts under federal law on January 20th. Given my issuance of the decision yesterday, the Superior Court has until January 17th to make a decision. That is assuming that Mr. Trump appeals the decision. Recognizing the logistics of ballot preparation, the compressed timeline, and the novel constitutional questions, I, in my decision, suspended the effect of that decision until the appeals court can rule or the appeals period expires. That means nothing will happen until we hear from the courts.